Another day has passed, and you have found yourself stepping back in to the court gallery. Ladies and gentlemen, welcome. I have a full evening of Judge Middleton prepared. We're starting the evening off with the opening monologue, and we're telling a whole story of the morning's docket with a few misdemeanor sentences and a little bit of a surprise spun into one misdemeanor sentence. And then we're going to backtrack a little bit. We're going to spin our archives back to December 1st, 2025, when a Mr. Warrants was first in front of Judge Middleton with his partner, and we're going to see their first case, their second case on December 8th, and their third case, which happened today, January 28th, 2026. And boy, none of them disappoint. I'm just not going to... If you want more information about all of these cases, check out the description. Ladies and gentlemen, once we're finished with Judge Middleton, we're going to Planet Washington, and there's nothing more you can really say about Planet Washington other than wow. We're going to end in Kansas with our favorite, my favorite, Judge Ricky, and it all starts right now.
Good morning. Today is another day here in Yakutia, where it's about 7 degrees, more snow. Most of the schools are open today. And we've got kind of a mixed bag. We've got a arraignment from a defendant that's in custody from the Department of Corrections. And he's in the Calhoun County Jail, and supposedly he's going to log in here in a moment. He was supposed to log in last Thursday, the day the courthouse was closed, and I came in anyway at 8:15 to do this guy's arraignment from the jail in another county, and they never logged in. So I got to see how flooded everything was. Anyway, then we have a landlord-tenant hearing, which was supposed to be a trial on Golden Pond Estates. And that, I'm not sure what we're going to do with it. Everyone was supposed to be here live. I allowed them to come by Zoom and do that. Miss Jackson is here to help us. She's got to be next door in about 2 minutes, so we'll try to be efficient with this. Everybody has lots of snow. Miss Jackson, what this is, this guy's in jail in Calhoun County. His probation agent wants to put him into a residential halfway house. We have a hold on him for this old retail fraud. So she wanted to do this. I think he's just going to plead.
Is he going to do maybe an instant pretrial this morning by way of Zoom?
I don't think so. I think we're just gonna see what he wants to do. It just got set on short notice by the staff. And the prosecutor doesn't even know about it. If he wants a pretrial, I'm gonna just bounce it to another day.
You can think they might be able to resolve it.
Well, it's a retail fraud and where he took $18 worth of stuff and then he was drunk at Taco Bell. So they charge him with drunk and disorderly. All right. Anyway, we've got that landlord-tenant matter. And I don't know how we're doing. Anyway, today's first line. Miss Jackson knows this. Sounds better if you sing it. I'm gonna skip the first word. You're breaking my heart. You're shaking my confidence daily. I'm down on my knees. I'm begging you, please, to come home. You're breaking my heart. You're shaking my confidence daily. I'm down on my knees. I'm begging you, please, to come home. If you sing it, you'll know it. I left a word out because that's the title. 1970. That's still a good song. Yes. People that are my age know it. Sing it, play it today. Listen to it. We'll have a shared moment of humanity. It's from the Bridge Over Troubled Water album, which won the Grammy for Album of the Year. All right, I still don't see the defendant. They're breaking my, oh, there they are. Hallelujah. All right, we're gonna go live. Good morning, sir.
Good morning.
Are you Robert James Vasquez Jr.? This is Judge Middleton. I'm here in Centerville and you're in the Calhoun County Jail. Your probation agent had tried to make arrangements for you to get arraigned on these charges last week, but there was some sort of I don't know what happened. Anyway, I was here, but nobody else was. But you're here now. Also present is Jeanette Jackson from the Public Defender's Office for this arraignment. In 2023, on the 4th of July, you got charged with 2 crimes and filed 231586 SM. Count 1 alleges retail fraud in the 3rd degree, which is at Walmart. It's alleged that you took about $18 worth of merchandise. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Then they allege that you were drunk at the Taco Bell shortly after that, and they charge you with being a disorderly person. Disorderly person is a misdemeanor, punishable by up to 90 days in jail and a fine of up to $100. As I understand it, apparently, excuse me, it wasn't Walmart, it was Rite Aid. You took some alcohol allegedly from the Rite Aid store without paying for it. As I understand it, at that time, you were on a conditional release from the probation center. And now your probation agent or parole agent wants to get you into some sort of a program. And this hold from Three Rivers is preventing that from happening, which is why they wanted to do this arraignment in such a hurry. Mr. Vasquez, are you willing to plead guilty to these charges?
I am.
Did anybody threaten you to get you to plead to these?
No.
Or threaten you?
No.
Do you understand that if you do plead to these charges, you'll be giving up your right to have a trial in front of a judge or jury? There will not be a trial. Do you understand that?
Correct.
If you had a trial, you'd have the right to be represented by an attorney. Ms. Jackson is here from the Public Defender's Office, but you could also ask me to appoint a lawyer for you. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath, you would have the right to take the witness stand yourself and testify, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you, and you have the right to be presumed innocent unless you were able to prove your guilt, unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Correct.
All right. What's the plan here for you to get out of the incarceration and go to a halfway house or a probation center?
Yes, the parole house. I did 25
And
months.
where is that?
That is here in Battle Creek.
All right. And you've been unable to do that because of this hold.
Yes. I tried to do a plea by mail while I was incarcerated in prison, but it doesn't seem that went through.
Well, that was me. I didn't want to do a plea by mail on these charges.
Okay.
All right. So how long have you been in limbo waiting to get into your program?
I think 11 or 12 days now.
All right. I'll give you credit for that time if you plead to these charges. Did you go into the Rite Aid store in Three Rivers on the 4th of July in 2023 and take a bottle of liquor and walk out the door?
I did.
And then did you go over next door to the Taco Bell and pass out in the bathroom?
Correct.
All right. On the retail fraud, I'm going to give you 12 days credit, 12 days, concurrent with the disorderly person. There's a minimum fine of $125. We're going to make that due by June 1st of 2026. On the disorderly person, I'm going to order 12 days credit, 12 days. This hold has prevented you from being released to go into the parole place, which is why your agent was in some hurry to get this accomplished. And I don't really want to jam you up on this minor incident from 2.5 years ago.
Thank you, Your Honor.
But you have accepted responsibility by pleading guilty. These will show up on your record. They aren't I don't think they're a parole violation. They occurred before you were, this took place, and your agent knows all about it and is trying to get these resolved. All right, I gave you 12 days credit, 12 days. When you get on your feet, you owe me $125. I can't make the fine any lower than that. That'll be by June. So when you get into the place, remember, you owe us $125 here in Centerville to resolve these matters. All right, you're good to go, sir.
Thank you.
Thank you, the Calhoun staff that got you logged in. Thank you, Ms. Jackson. That took 6 minutes.
Okay.
So, hello, Colin Raiders. This is your obligatory Colin Pauls. Welcome to a big docket full of Middleton with a recap of Millerand's case. Check out for more information in the description. And we're going to get right back into it. Welcome, guys.
The tricky part.
But you gotta turn the comments and everything on.
Yes, that takes 17 steps.
Does it?
Remember in the old days that we just was Wild West? All right, so I go over here to create. And then I go live. That's 2 steps. 3, 4.
Wait. I didn't even see what you were doing there. Are those just ads or something?
Yeah, something like that. And I go to manage. And then I go to here. And then that's when the comments start. Good morning, everyone. Here's our friends from California, both of them.
Hi, Julie.
And Martha are both here.
Hi, guys.
All right, Judge Stutzman is going to be starting his live streams next week, and we'll have a little bit of a refresher. So we go over to settings and edit,
Oh, my God.
and then we go shut off live chat. And then details and make it education. Save it. So that turns the comments off. We are live. So,
So it's going now.
so it's going now, and the comments are turned off. I let them run for a bit in the morning when I do my
Your opening
introduction.
monologue.
My opening monologue.
All right. I'm in. All right.
I'll come up and look at, where are you gonna, you'd be doing this remotely?
Well, this month I'm gonna start it from here so I get used to
All
it.
right, I'll come up when you're gonna do it and,
Okay.
and go through it on your computer.
Thanks, sir.
But yeah, you were the expert originally. You got us going in May of 2020. How long we,
I stopped it as soon as I could. I'm only doing it now because I have to.
all right, we'll take a short recess here. We'll be back.
Right back.
Mr. White, why don't you come up and have a seat? We were first compelled to do live streaming because the courts were closed because of COVID. And the court proceedings are to be public. So the solution was we did everything by Zoom. So in the early days of all this, May of 2020 and through that first year, everything was live streamed and the live chat was left on. We didn't even realize what it was. As soon as we were no longer required to live stream, when the courts were open again, the other judges here in St. Joseph County stopped, and I continued to live stream my proceedings. And I plan to continue when we move to the historic building. Judge Stutzman, however, is going to have to do some of his matters remotely, either from his office or from some other location while the construction is going on. And so those matters are going to have to be live streamed. So he will be starting his live stream again, I think next week. But he was the one that originally taught us all how to do it. The programs have changed some since then, and he's going to get reacquainted with it. So we'll work on that. All right, good morning once again. We're here for the sentencing in People versus Robert Lee White, 252284. Good morning, Mr. White.
Good morning.
Mr. White was here in a timely manner, reading. The attorneys have been discussing the matter. Present is his attorney, Ms. Casey Strong, and Abby Stoll is here from the prosecuting attorney's office. This is a FY case, which stands for a felony. It started as a larceny over $1,000, but less than $20,000. This allegedly occurred in the summer of 2025. The defendant was arrested in November of 2025. The felony charges were dismissed, and the defendant entered a plea to a misdemeanor charge of larceny more than $200, but less than $1,000. That was done on December 16th. This alleges a number of thefts of wire and other property that belonged to Forest River. There are apparently videos of some of this, and there's some other evidence. There's a co-defendant, Peggy Lytle, who has yet to be arrested. There's an open warrant for her arrest for this same set of circumstances. At any rate, Mr. White entered a plea, and the matter was set for sentencing. It was set for sentencing on January 21st, and the defendant called and said, I can't get to court. The person I'm riding with has a diesel truck. It won't start. It was very cold that day. Schools were closed. The roads were bad. We simply agreed to continue the matter until today. It had been set for sentencing well, earlier in December and early January, we were trying to determine what the restitution amount would be. So the matter was adjourned from the 21st to today, the 27th, and here we are. Joining us now is Angelique Camfield from the prosecuting attorney's office. And she was attempting to get more information regarding the restitution issue. And it's hard to determine because there were more than one incident. It's hard to value this property. What is its value is for its intended use, or what is its value for scrap? Those are issues that could make restitution difficult to nail down. At any rate, as I indicated, Mr. White entered a plea on December 16th. I talked to him about it. He acknowledged responsibility for this, told me that he stole this property. I'm advised this morning in chambers.
I wasn't aware that I was stealing, sorry.
All right, that you wish to withdraw your plea.
Yes.
All right. You told me you knew you were stealing. I don't know how you would not know you weren't stealing.
There was no signs or anything, Your Honor, and the guy that told me about the place said he's been getting wire from there
All right.
for over 2 years.
All
Your Honor,
right.
I just want
All
to do a blanket
All
Fifth
right.
Amendment. If this is going to be withdrawn, I want to make sure Mr. White understands fully that we are recording and anything he says could be used
Yes,
as an admission.
So, yeah, so don't say anything. The problem is, it wasn't yours. It doesn't matter that other guys were stealing from it. It wasn't your
There was no
property.
signs
Stop.
of-
Stop. And it had value, or you wouldn't have taken it. So apparently there were multiple incidents of this, but the upshot of this, Mr. White, the felony charge was dismissed in exchange for your plea to a misdemeanor. Are you advising me this morning that you wish to withdraw your plea and have this matter set for a preliminary examination on a felony charge?
Yeah, Your Honor, because I don't see where there was a crime committed, really.
All right.
It was more of
Don't say anything more. I'm not unwilling to hear what you have to say, but as your lawyer says, anything
Yeah.
you said can be used against you. The law in this area, we discussed this in chambers, whether I agree or not, the law says that when someone moves to withdraw their plea prior to sentencing, the court shall grant that motion to withdraw the plea with great liberality, meaning the law favors allowing the defendant to withdraw the plea. Whether I think it's a wise idea or not isn't part of the equation. You're turning a misdemeanor back into a felony. And what would the next step would be to set a pre-exam conference and then ultimately a preliminary examination. Ms. Canfield, were you able to get any restitution information?
I did get some restitution information, Your Honor, and they're in the process of gathering the documents in support of that. But what I can relay to the court and counsel is that I spoke with Mike Getter, who is one of like the main general managers of the company, and he then has the subsequent plant managers that oversee things. The purchasing agent for the White Pigeon plant is Dorothy. And Dorothy was gathering some documents for the alleged drum of wire that was stolen, some receipts for their scrap metal that when they turned it in for money, they earned $1.26 a pound. And she says each drum, if you will, was 600 to 700 pounds. And there were 9 of those that had been taken over the course of these few weeks. There was also an entire drum of new wire that was taken, which was presumably something the company would use throughout the business. So that was not scrap. That was $1,702. And then they allege that power cords were taken. I think the defense would be able to point out that in the video, there aren't any power cords in the wagon. There are none that were demonstrated for the defendant to be near, at least on the one occasion that it was videoed. But what the defendant turned it in for, and the receipts that are in the police report indicate that he earned $4,243 off of what he had taken and turned in. So that is the very least amount of what restitution would be, is what he had earned off of it. But I do believe it could go upwards of $14,371, depending upon the court's determination of it after a hearing. The plant manager, for what it's worth, for the defendant and his counsel, had indicated to me that if there were a sanction and a jail sentence, while they would like the restitution back, their main concern is for somebody who is a repetitive theft from their property. They would like some jail, and they may be willing to forego restitution for a jail term. So I just wanted that to be on the record. Because, I mean, if a plea is withdrawn, we will not be making any more misdemeanor offers, and this will proceed as a felony. And I will try it as a felony. So that is the one caveat for the defendant that's important for him to know, and I know the court's already mentioned it.
And for the sake of the record, I did discuss that in the abstract with Mr. White, because it had not been officially extended, but we had that conversation as well.
For the record, the guy stated that he did not care about the wire that I was taking.
All right. So some unknown person, apparently somebody cares about it. So do you wish to withdraw your plea?
Yeah.
I would just state, the court will, for the people, we obviously want to just object to that based upon the fact that there was no error in the taking of the plea. The defendant read his rights, he understood his rights, he had representation. The court was very clear in its taking of the plea. The defendant admitted the offense. And the other portion is, so if there's no error in the taking of the plea that mandates a withdrawal, there has to be a manifest injustice. I don't believe that's been demonstrated by the defense. And I do think also, I don't know that there'd be prejudice to the prosecution necessarily, Your Honor. We have the witnesses available, so I don't know that that element applies.
Well, I don't know about the manifest injustice standard, but yeah, there is a prejudice to the state. For example, let's say this was a plea that was taken on an assault case. And after you entered the plea, the complainant was killed in an automobile accident. And they would be unable to present the complainant.
Well, I feel that there was no.
Stop. I understand what you feel. I don't agree with it, but I understand that's your cockeyed theory of it. My sense of this was a giant gift. The amount stolen is at minimum $4,000 and up to $14,000. If you want a felony, I guess you can have one.
May I say something, Your Honor?
All right, I may stop you, but yes.
I've been in here several times. I've always stepped up, to take responsibility for what I've done. I don't feel that, I know for a fact that I didn't take no power cords out of there, and I didn't take no big spool of wire either.
All right, one of the things, a lot of stuff was stolen, and you may not have been the only person stealing.
Yeah, I just, they've
got some issues regarding that, but the other issue is your counsel had met with you, advised with you in good faith, and worked out this misdemeanor plea to your advantage, and now that the sentence is nigh, you wish to withdraw your plea. It's not fair for her to have to continue to represent you in this matter. I will release Casey Strong as attorney. I will allow you to withdraw your plea. as I said, this was in my mind, a generous plea offer. It would be something they could try. The problem is they got a bunch of other much more serious cases than this that need to get tried. And so sometimes you have to make a decision and resolve the less serious cases to make room for the more serious cases. So this doesn't trump a murder case or assault with a hammer or a criminal sexual conduct case, the kinds of things that are pending. So, but you do have an absolute right to have a trial. Where are you living?
Staying in Sturgis.
Are you at the Maple Street address?
Yeah.
Are you really, or just sort of homeless?
I don't know. It's my dad's place.
All right. I would have just set it for a prelim, but we're gonna get new counsel. And it wouldn't be fair to them to appoint it and just set a prelim. So I'm gonna set a pre-exam conference for February 10th. At 8:30. And the preliminary examination for February 17th. At 1. So we're back to square one. We haven't accomplished much between December and now. One of the things in here is you denied everything. Peggy Lytle admitted everything. According to the affidavit, she says, yeah, we understood they were stealing stuff. How many times they stole what?
She told him that we.
All right, stop. So you denied anything, knowing anything about anything. You didn't say some version about, hey, some guy told me I could take this. You just denied it altogether. And then she said, yeah, we've been stealing this stuff. They were out here 2 or 3 times this week. So she hasn't been arrested yet. I don't know where she is. I don't know if anybody's even looking for her. But as I said, if you want a felony, I guess you can have one. You can go to prison for this, as opposed to a jail sentence, but you've stated your position. So we'll set a pre-exam conference for February 10th at 8:30. I suspect your new lawyer is going to tell you the same thing that Ms. Strong told you, that this misdemeanor plea was a good offer. But we won't proceed with the sentence today. In the meantime, the prosecutor will continue to work on that restitution figure. So I want you to go out to the counter. We're going to appoint a new lawyer for you, set a pre-exam conference for February 10th, and a prelim for February 17th if needed at 1 o'clock. I'll do an order allowing the defendant to withdraw the plea and allowing Ms. Strong to withdraw as counsel.
Thank you, Honor.
All right, thank you.
Thank you, Your
So
Honor.
counter is the district court office.
All right, that's as far as we got in that. So our next matter, our 130 matter, is Golden Pond Estates versus Travis Millerans and any other occupants, which include Randy Bailey. Mr. Steve Cromendike is here for the plaintiff. I had a little trouble interpreting the pleadings, but Mr. Millerans, they want you to move and terminate your tenancy. That would give you 10 days to move out, 90 days to move or sell your mobile home. They allege some violations, but I can't yet tell what they are because the pleadings weren't very clear. Mr. Cromendike, you wish to speak to that?
Yes, we're waiting on getting some police reports pursuant to a FOIA request and are still waiting on those. And we've been waiting for quite some time. So I don't have those now. It is my understanding that the police have been at the park related to Travis's behavior a number of times recently. In addition to that, I've got a couple of notes here, and Mr. Dave Elliott is present regarding some altercations with Travis and Dave, who was doing some maintenance at the park, threatening, Travis was threatening Dave. I've also got a couple of voicemails to another park manager that were fairly threatening, and some complaints from neighbors as well.
Well, Mr. Miller, that doesn't sound very good. What's your response?
Threatening me, you mean?
Are you Travis Millerans?
Yes, sir, I am.
All right, well, they want you to move out. What do you think of that?
I'm not moving out nothing. They don't have no reason to kick me out. I didn't do nothing wrong.
But I can't watch it full now. Yes.
Dave is the problem.
Times more cleaning power, plus it contains plenty of food.
You are, bud.
Okay.
There's no.
I have been in contact with Meg as well. She just isn't present today.
We have an attorney.
He is on a bench trial right now, so she's not present today.
I spoke to Meg last
All right,
week.
well, here's what I can tell you from my files, Mr. Cromendike. Mr. Millerans was charged with domestic violence second offense in 2 file 911 SM, pled to disturbing the peace in front of Judge Patterson. Excuse me. And he hasn't paid the fine. Then in the most recent case, 251627, charged with resisting and obstructing a police officer and domestic violence from August of 25. He's on probation from Judge Patterson here at the court. That is file 251627.
They brought it.
He isn't making his payments in that either.
His probation officer told him to pay for his anger management class and everything before he started his paying on his fines.
All right, that probably makes sense. Let me get those numbers again. 251627 FY. And these are just the ones from 25. 25911 SM.
What was that second one? 25911.
SM. That was a disturbing the peace. I believe that was at the park.
Okay.
It was between me and Travis.
Yes. And I believe the other one was also at the park.
Yes, between me and Travis,
right.
because my nosy neighbor.
Well, apparently they don't want you to be there anymore. They'd like you to move your trailer and go away. The law says you're entitled to have a second hearing in this matter. And you allege that you've contacted Megan Bauer. Which means we're probably going to have a hearing, but let's pick a date, Mr. Cromendike. Next Monday seems to be good. We're through the Thanksgiving holiday. And
Next Monday, the 8th.
Yes.
It would need to be in the afternoon for me.
2 o'clock. Does that work for you?
That will work.
Continue to December 8th. 2:05 at 1 o'clock, at 2 o'clock. May
And I will-
ultimately get a hearing.
In between now and then, I will send in
It was stop thinking about it.
some of the voicemails I have and other documentation.
All right.
That night.
All right, Mr. Millerans and Miss Bailey, let me
Yes.
repeat, they want you to move. They want you to take
Right.
your trailer out of their park and leave. And if they got what they asked for, next week, I would give you 10 days from December 11th to move the trailer and 90 days, or 10 days to get out, 90 days to move or sell the mobile home. We may need to actually have a hearing on this before we get to that point. I'll pull the police reports from those other two cases that I quoted and see if they happened at the park. At any rate, you stay in contact with legal aid. If they are going to represent you, they'll file an appearance. But we will be back here next Monday by Zoom at 2 o'clock.
Your Honor.
I
Yes.
think Meg said she'll be gone on the 8th.
Well, if she's
she's,
gonna file an appearance, she knows what she needs to do.
Oh, okay.
If you are
I'm
able
not
to,
Go ahead.
if you're able to get copies of those police reports, is there any way that I could get a copy of them as well?
Yes, if they did happen at the park, I will email them to you.
Okay. Appreciate it.
Well, what
All
is
right, thank you.
what are these?
I'll
What
see
are these
you,
police
both
reports
next week.
about?
What?
What are these police reports about?
I don't know yet. One was the DV between you and Randy at the park.
That has
Back in
nothing to
August.
do with nothing.
Yeah, the allegations on that paper
That was
involve
against
him
Dave.
and Dave.
But Dave don't like me. That's the only reason why they're trying to get me out of here.
Well, all right, that's one reason, I guess.
Yeah, well,
Um,
they're gonna have fun, because I ain't going nowhere.
Okay, well,
My trailer's too old to be moved. No trailer out
yes,
here
they
can be
generally
moved.
are. You'd have 10 days to move it
I've
or so.
Been here for 11 years.
All right, well.
And I
that's
also
good fun.
paid my rent today.
Say that again?
They're
I-
taking my rent money?
I paid my rent today.
Well, they're not supposed to take your rent once they file a motion to terminate
Well,
your
I've been
tenancy.
paying my rent every month faithfully. I
That
paid
could be an issue, Mr.
$474 last night.
All right, we'll address that.
Yeah, I'll have to take a look at the ledger. It's an online payment system, Your Honor, so I'll
Yes.
have to see.
And if I'm getting evicted, I want my money back.
Why? You're still there. You're paying for rent for time that you're actually there, not future rent. Anyway, we'll address this further
Okay.
next month.
What do you mean why? Because if I have to move, where I need that money, that's why.
Yes, okay. But
Like,
you're
I'm not
living
trying to
there.
be.
You've just paid December's rent. Well, we'll address it next week. It'll give me
Okay.
something to look forward to. Thank you.
Almost $800.
you.
I need that.
Okay, I believe you. Now we got a bunch of people in the waiting room. Plus, we just found out we have somebody in custody. We've got our parties here on our general civil matters. And I don't even know who's here. This is Golden Pond Estates versus Millerans, Travis Millerans. Also occupying the premises is Randy Bailey. Ms. Bailey, is Mr. Millerans with you?
Yes, Your Honor. He's right here.
Yes, sir. I
All
am.
right, hello, Mr. Millerans.
I'm gone.
That's going all right for a cold Monday afternoon. Mr. Steve Cromendike is here for the plaintiffs. This is a termination of tenancy matter, just cause, 3 lates and 12 months, and I think other just cause. They want you to move your mobile home off of this lot, number 3. You don't like that idea much and expressed that last week. You have filed a written demand for a jury trial. And we received that on December 5th, and I believe you also paid the $50 jury demand fee. Mr. Combative, what's your position?
Just to be clear, this is not, this just has to do with health and safety concerns, not with
Yes,
missed
not three
payments
late.
over a 12-month.
Yes.
Yep.
I'm sorry, we said that last week.
Yeah, so and where we had left it last week, I think my assistant submitted some of the documentation I have. There have been some incidents with Mr. Elliott, who is on the Zoom call here, who is does maintenance for the park. And so he's attending, and if you'd like to hear from him, we had left it last week that had made a FOIA request and was waiting on police reports, as the police have been there a few times, but still do not have them. I think you had said you were going to call and see if you could get a copy of them as well. When we reached out to your office earlier this morning, it sounds like you hadn't or didn't have those yet. So I don't have any police report.
I got our file numbers. And at least I only know the things that resulted in a charge.
Okay.
So if there was a charge, we'd have a file number. If there was a complaint made, I don't have that. At any rate, the defendant has filed a jury demand, and so we're going to need to set this for a hearing. Also, I got I didn't know what it was. During the lunch hour, I got an email. And I opened it before I really knew what it was. And it was apparently Mr. Millerans bitching out Golden Pond Estates, cursing at him.
Yeah, that was my assistant sent that over just as some. That's the documentation, shall I say, that we have. So I wanted to make sure that you had it.
All right, we're going to need to set this for a hearing. Mr. Millerans, can you hear me?
I can.
All right, you've demanded a jury trial. I started here 23 years ago. We've yet to have a landlord-tenant jury trial. Judge McManus was here for 36 years before that. I think maybe he had one. You don't know the rules of evidence. You don't know the rules of procedure. You don't know how to introduce evidence. And you want to have a jury trial where you're going to bring in 36 of your fellow citizens, try to represent yourself in this case, selecting a jury, making an opening statement, presenting evidence, cross-examining witnesses. It isn't as easy as it looks on television. Now, you had indicated that you were going to have Mick Bauer represent you. I have not seen anything from legal aid, and Ms. Bauer's been gone on a trip. What's your position?
She told me after today's court hearing, I have the email to contact the office and set an appointment with her, so they can further decide if they're going to fully take on this. She advised me to file this, and I did. My position on it is, you're very correct. I will have everybody in this park against them. Currently, there's sewer backing up in people's homes.
And don't even want to pay the bill.
And this happened as of last night. And has been like this for a week.
Oh, and
say that again, your sewer backed up?
Yeah, it's in more than one person's trailer, and Jared is complaining about it, but this is
did it back up into your trailer?
Yeah.
Okay.
But this is a problem from lot 1 to lot 7. There's tree roots in our ground. And if they would do the proper investigation from what everybody knows out here for 11 years, then they would know that this is an ongoing problem and they're going to have to deal with it, whether they like it or not.
Those may be two separate things. Now, if you are threatening to beat up the personnel at the place or doing other things,
that never happened.
Stop. What I heard, and I didn't really know what it was till I opened it, is you calling them up, being very rude and disrespectful and swearing at them and telling them you're not going nowhere. This is your home. Once
It is my
Meg Bauer hears that, you probably won't want to touch this with a 10-foot pole.
She knows what has been said. I've told her.
And I'm not trying to be rude, but this Dave guy, ever since he took over this park, he's treated nothing but all of these tenants in this park like trash.
Like we're lower than a
Well, let me
low.
ask you this. If it's that terrible there, why
No.
don't you want to move?
Because he's barely ever out here.
Because I've lived here for 11 years and this is my home.
Well, you own the trailer, you don't own the lot that you're on.
Travis said he's more than happy to sign like a conditional dismissal to where he has an agreement with the whole park and with Dave and Jared and everything to where he won't get in trouble, where he won't say nothing to nobody or anything. Like I stated last week, though, he also is getting ready to take anger management. He does have mental health problems. His medication interacts with each other, and he has an appointment December 15th regarding his medication. And I do have witnesses to the fact that Dave came running all the way from the end of the trailer park to get in Travis's face when it had nothing to do with me and Travis.
All right, now you are listed as all other occupants. There is no lease here. Mr.
Right, because when I
Cromendike.
go into the email, it won't let me sign it. It never would.
Slow down. Mr. Cromendike, was there a lease at one time?
I believe so. I can go online and check right now if there is one.
No, there's not. But if you go into the app, it says my lease is good until 2026. But I haven't signed a lease because every time I open it, it takes me right back to the app and it don't give me an option to sign anything. And I've been trying to figure that out since
Ms.
August.
Bailey, slow down, slow down. Was there a lease at one time?
No, I haven't had a lease since they took over the park.
Yeah, I do not see
When was that?
a lease in here. I'm not sure when they took over this park. Dave or Casey, can you guys speak to that?
It's been probably close to a year. It's probably right at about the year mark.
It's about a year and 2 months, 3 months.
So you don't even have a lease. You're
Which
living
isn't
there.
my fault.
Well, it isn't a matter whose fault it is. You don't have one. A
There's a
lease
lot of
gives
people
the
who don't.
tenant certain protections, and whatever previous lease you had is lapsed. So you're living there without the benefit of a lease, which means you're what's called a tenant at sufferance. And they want you to move and remove your trailer. So you don't have the protections that you would have in a lease, because whether you didn't sign it or they didn't sign it, there is no lease. So you don't have the protections that a lease provides. You got a tiger by the tail. You filed a jury demand, apparently on the advice of Meg Bauer. And so I don't have any discretion to circumvent that. We need to set it for a jury trial.
I mean,
And,
Travis is more than happy to start doing stuff. Jared and Travis have spoke before Dave and Travis got into this argument that had nothing to do with me and Travis. Jared had told Travis last year when there was a problem with Dave.
Well, who is Jared?
Oh, he's the owner that nobody even knows.
Jared is one of the owners, Your Honor. He's a member of the entity that owns it. Jared also owns the property management company, which handles management of the park. So I'm when he's talking with Randy and Travis, my suspicion is that it's in his capacity as the owner of the property management company.
Yeah, Travis and Jared had an agreement that if there was a problem out here, Jared would speak with us instead of Dave. Then it went from nobody communicates with anybody.
No, because, oh, that's right, because they don't have time for this trailer park.
We don't even have a manager out here to report anything to. I have text messages from Jared telling me it's not his problem to worry about things out here. Let the police handle it. Okay, the police stood on my porch and told me multiple times to get Jared on the phone or a manager because they wanted to speak to him. They refused.
All right, well, this is filed as a termination of tenancy. They allege numerous violations of the park regulations and procedures. You don't have a lease, so you don't have the protections.
I don't
of
even
the
know what
lease.
the rules of the park are.
Good point.
And I've never had a
Anyway.
violation.
Well, they're alleging that Mr. Millerans has. And
Well,
these
I mean,
foolish
where are those
voicemail
papers?
messages you just left
Well,
do not help the situation at all.
where's this written proof at?
Because we've really never been wrote up for anything.
Well, I guess we'll find out.
And how am I such a bad person out here when all I do is
Well,
try to
I'm
help
not-
people out?
I don't have an answer to that because I haven't heard the evidence yet. But they want it sooner than later. I'm going to set it for jury trial for January 28th, 2026 at
Like this
8:30.
is ridiculous.
Well, maybe so, but I didn't
Yeah.
bring this case. They did. They want you to move. And so they brought this lawsuit to get me to compel you to move. You've demanded a trial in front of a jury. And you have a right to do that. You've paid the $50 jury demand fee. You don't know what you're doing. You don't have a clue one. It's how
It
to pick
doesn't
a
matter if I
jury or
know what
how
I'm
to.
doing, Your Honor.
I
But if Nick
filed it.
Bauer,
My
What?
wife is going through school for everything.
I'm in law
What you're talking about right now.
Literally.
We know what we're doing.
I know how to
You're
pull the
in law
MPL
school,
codes and all
Ms.
that.
Bailey?
Yes, I am.
Law school, yes, she is.
At where?
Southern New Hampshire University. Have been for 2 years.
Southern New Hampshire University is an online university. I don't think they have a
Yes, they do.
an accredited law school, but you're
They do.
apparently. Well, all right.
We don't know what we're doing.
All right, so
But no, I mean, we're more than willing to sign paperwork, stay in. Travis won't say anything to nobody or get in trouble or do anything like that, which is a conditional dismissal. Obviously he's gonna take anger management that I have to pay for $250.
How would we
Part of his
define what,
probation.
how would we define what getting in trouble is in a conditional dismissal?
I mean, I've had one before, so I'm sure Judge Middleton could explain that to you.
well, he knows what it is. He was just wondering whether you understood what it is.
Oh, no, I understand because back when I had 3 other owners prior, they did do one with Travis because of my neighbor. That still is a problem.
I've even asked Jared when he took over this park.
All right,
I-
just stop.
Why can't I
Set a
talk?
jury.
Your Honor?
Because I didn't ask anything. You don't just blurt stuff out when you're in a courtroom. I'm trying to schedule this matter for your requested jury trial. We're not taking any testimony at this point. Nobody's under oath. Now you guys can discuss it among yourselves and see if you can come to a conditional order of dismissal. But they filed to terminate your tenancy for multiple violations. You filed a demand for a jury trial. So I'm gonna set the jury trial for January 28th at 8:30.
And will I be there in person?
Yes, your
Oh, I
witness
won't
and
be.
exhibit lists are due by January 9th.
Okay.
I won't be there.
Why not? You don't want to be there on January 9th?
28th.
28, no. We're gonna have witness and exhibit list due by January 9th. We're gonna set a pretrial conference in advance of jury.
And we got a lot of people out here backing us up.
And you need to subpoena all of them.
All right, we'll get right on there.
And now, in the meantime, you can discuss some sort of potential conditional order of dismissal. There are lots of issues at this park. It's a transition from an old privately owned to a new partnership owned property. There's well issues, there's septic issues, which predate everybody here.
Right,
except me.
pond water.
This juncture, though, they simply want you to move. You are adamant that you don't wish to move. You don't have a lease. You don't own the lot. There are habitability issues with the lot if the sewage is running back into your trailer. But I'm gonna try to force this to a head. Now, all your witness and exhibit lists are due by January 9th. I'm gonna set a pretrial on that day. That's an ugly day. Oh, gee whiz. Already got a trial set that day. I wish they'd put the name in there. I've got a termination of tenancy case set for that afternoon. Oh, it's Williams. Dude. I'm gonna set it for Friday, January 9th at 11 o'clock. Eleven to 12 pretrial. So you have to file your witness and exhibit list by that date. I would ask you to file your jury instructions, but I don't want to put Mr. Cromendike to that until we actually decide whether we're going to have a jury trial on the 28th. But you have to submit your witness and exhibit list. If you got 27 witnesses you wish to call, you have to provide for them to be there. You have to subpoena them or get them to agree to come voluntarily. We'll block out one day for this jury trial. I'm not gonna spend a 5-day chasing my tail over this. So in the meantime, you can discuss a potential conditional order of dismissal. Mr. Cromendike, I'm willing to put everybody, you and Ms. Villa and the defendants in a breakout room right now to discuss some of those things. I think Mr. Elliott might just add fuel to the fire, but I'm at least willing to put the three of you in there. What's your perspective on that?
I'm not against it at all.
All right.
Mr. Elliott,
you're good. What?
Before you do you know when Meg is going to be back from her vacation?
No, I don't. She was gone and then she was gone again. I haven't heard whether she's going to file an appearance in this matter. According to Miss Bailey, she's the one that told him to file the jury demand.
Yeah, I can send that to Mr. Cromendike. I mean, I have no problem even showing him what Meg told me.
All right, you guys can discuss some of that.
Was adjourned today. She told me to call the office after the hearing today and schedule a phone appointment with her. But they couldn't do nothing because she was going to be gone, so she couldn't accept the case because she was going to be gone. But now after this hearing today, I'll have to hang up and call them and schedule an appointment.
Well,
with her.
if legal aid gets in, it will be in a better posture.
And
but for now,
I did
they're
talk
not.
to Meg about this beforehand as well. So I have talked to her about it already.
All right. Does it sound like she was gonna get in it?
She wasn't sure at the time.
All right. The email that you forwarded to us,
Yeah.
I would suggest perhaps you share that with Ms. Bauer also.
Yeah.
All right, I'm gonna put you guys all in a breakout room. At
Thank
least you can talk for a while. Mr. Elliott, you're good to go.
All right, thank you, sir.
All right, thank you. Good morning, Ms. Bauer.
Good morning, Your Honor. I will be filing an appearance in this matter on behalf of Randy Bailey.
All right, I wasn't aware of that, but I don't have any objection to it, but it does, we're already in a confused posture here today. Ms. Bailey and Mr. Millerans, would you join us, please?
Yes, Your Honor, we're present.
All right, Mr. Millerans there as well?
Yes, Your Honor.
Oh, boy. Mr. Millerans? Would you get up and put on a shirt?
Yeah. Yes, Your Honor. I'm actually trying to find a shirt right now as we speak, Your Honor. Sorry about that.
This is a trial. Boy, I can tell you have great respect for the process. All right, the title of this case is Golden Pond Estates versus Travis Millerans and Randy Bailey. They wish to terminate their tenancy primarily because of the misconduct of Travis Millerans, who shows up for court without a shirt. Mr. Steve Cromendike is here on behalf of Golden Pond Estates. We've been tussling with this case since early December. Randy Bailey is present, and Meg Bauer is here from legal aid. Theoretically, this matter was set for a trial today on a termination of tenancy. Mr. Millerans and Ms. Bailey wanted a jury trial, and they don't have the wherewithal to conduct a jury trial. They didn't file the information in a timely manner. I didn't set the matter for a jury trial.
Wait, Judge, I'm sorry. Did they not file in a timely manner?
I can't remember. Maybe I'll take a look. Maybe they did. So you're contending there's a jury demand in here?
Yes, my understanding is that they filed a jury demand within the 5 days of the first hearing and paid the jury demand fee or had it waived.
I'm not sure that's accurate, but all right, let's assume for the sake of argument it is. I set this for today. All their witness and exhibit lists were due by January the 9th, which they filed on January 28th.
I don't believe the plaintiff filed a witness or exhibit list in this matter.
No, they didn't either.
Exhibits.
So plaintiff filed a motion for summary disposition that the defendant has not had an opportunity to answer, and they amended the complaint that the defendant has not had an opportunity to answer. So if I understand correctly, Ms. Bauer, you'll be representing only Randy Bailey?
Randy Bailey is the listed client in our system. If the court would prefer that I make my appearance on behalf of both defendants, I can do that. And I am primarily motivated to be involved in this case based on the procedural confusion.
Well, one problem is Randy Bailey and Travis Millerans they have conflicting interests. The primary reason they want to evict Ms. Bailey is because of the conduct of Mr. Millerans.
You have articulated my apprehension about appearing on behalf of both defendants.
All right, why don't you go ahead and place your appearance on the record as who you're appearing for.
Thank you, Your Honor. Attorney Meg Bauer, P84816, appearing on behalf of Randy Bailey.
Your Honor, if I may, Meg and I talked for quite a bit yesterday afternoon, Meg, about a potential conditional dismissal here and what terms of that would look like. I have not been able to follow up with you until now about it. You said you were going to talk to your client, which I suppose is just Randy at that point, at this point. But in any event, has there been any progress on that?
Well, I'm glad that Meg is here. These people could use some help. They claim that they had legal knowledge, which they don't, and that you guys can discuss this matter in a rational manner. And nobody wanted to be here today. I appreciate, Mr. Commandant, you were gonna have to drive down here from Holland and everybody would have to be here. So on short notice, I turned this into a Zoom hearing. Ms. Bauer, do you think there'd be any merit to you either discussing it further with Mr. Commandant or with Ms. Bailey in a breakout room?
I did speak extensively with the tenants last night, and I thought that Attorney Cromendike also needed to speak with his client. So I have a little bit of an understanding of the range of possible settlements based on my conversations. I am hopeful that something is possible.
I've talked to my client, and I believe he's on board.
All right. How about if I put Ms. Bailey, I'll put you in the waiting room. Don't go away. Meanwhile, Mr. Millerans can get pants and a shirt. And I'll put the two of you in a breakout room and see if you can get the details of the conditional dismissal. And maybe we can have some good result here today.
And Judge, I made it clear to Ms. Bailey that I was going to articulate this to you. But my presence here is primarily in service to the court. Obviously, I have an ethical obligation and legal duty, but.
Well, I've already said, I appreciate your being here, and you all very often help resolve difficult cases, and I do appreciate that. All right, I'm going to put both of you in a breakout room. I'm going to sit here and think deep thoughts for a while, or maybe not so deep thoughts. All right, I'll give you both the first line of the day. You're breaking my heart. You're shaking my confidence daily. All right, you guys think about that.
I know it. I just can't think of the next line now.
Sing it. That'll come to you. I didn't give you the first word. The first word is the title. You're breaking my heart. You're shaking my confidence daily. I'm down on my knees. I'm begging you please to come home. All right, you guys go in the breakout room and I'll think about that.
I'll practice so I can get my Oscar next time.
All right,
Because I don't even know what it.
I'll leave it to you guys.
Well, the album is about 55 years old, it's Mr. Cromendike, but you might know it. All right, we are back on the record and back on the live feed in the matter of Golden Pond Estates versus Travis Millerans and all other occupants, which include Randy Bailey. Miss Bailey and Mr. Millerans are here. I assume you put a shirt on since we last saw them. Meg Bauer and Steve Cromendike have been discussing this matter at some length in a breakout room. And Ms. Bauer, I'll defer to you. What's our current status?
Thank you, Your Honor. Attorney Cromendike and I have had extensive conversations, conversation about the range of settlement terms. And although we're close, we've got a few details to massage out still. So for that reason, we'd like to ask the court to schedule us to keep us on track, that perhaps we have the court schedule a pretrial, perhaps a deadline for witnesses and exhibits in a couple of weeks. And we were discussing that ideally the week of February 16th, but obviously depending on the court schedule, with the hope that we'll have a settlement that we can have executed and entered at that hearing, but understanding that that's a turning point to keep us on track.
All right, the clerk did bring in the jury demand. It was in the file. I couldn't find it. It was filed within 5 days of the original hearing on December 5th, and the defendant did pay the $50 jury demand fee. So theoretically, this case would be set for jury trial. There are a couple concerns. I don't think there's currently any valid lease in effect. Do you agree with that, Mr. Commandike?
I do.
We've been tussling with this, as I said, since December. Will be December, January, and February. There is no escrow order in place. Is a plaintiff requesting one?
We're not, and frankly, there hasn't been an issue with payment of rent.
And Ms. Bailey, we've discussed the portal being unlocked.
All right.
Thank you.
All right. Let's look at February 16th.
And
That might be President's Day.
and my thoughts were that we don't bog your schedule down with a day blocked out for a trial at this point. Because if it's not necessary, we keep the date open for the court.
February 16th is a holiday. I normally try to be gone during that holiday, but I'm not.
I think.
Let's look at February 13th.
I think
13th, I'm going to be out of town.
All right.
Steve, are you okay with the 20th? I know that's typically the landlord-tenant days are Mondays and Fridays.
20th would work.
I have an important appointment at Sunset Key, which used to be called Beer Can Island, on February the 20th.
My apologies, Judge. I wouldn't want to interfere with that.
I've got to go buggy unless I get out of here again. What's this? That takes us all the way, I apologize, to February 27th. Friday,
27th
February
would work
20th.
for me.
All right. At 11 o'clock. It's going to be problematic because I'm missing so many Mondays and Fridays in February. The days are going to be kind of dense, but I think I may be able to put some things in the afternoon of that day. So we'll block out 1 hour on Friday, February 27th at 11 to 12 for status conference. If the matter is resolved before that time, you certainly can file a conditional order of dismissal at any time. Miss Bailey, Miss Bauer has filed a verbal appearance, and she'll file a written appearance on your behalf, and you've been discussing things at length. Mr. Millerans, my advice to you is that you continue to keep things on a low profile. There are a number of things that you are alleged to have done, which is why they want to terminate your tenancy. So my advice, but I don't, we haven't got to that issue. They're accusations. So just don't bring up any more accusations. I don't want any more disturbance or discord out there. That'll just make their case easier. All right. Parties did work at resolution, weren't unable to get there.
Well, that's a question.
I'm allowed to speak.
Yes.
It's actually for Mr. Commandike. Because I was locked out, of the portal, can the $50 late fee that was put there for January's rent be removed? Because Casey did.
Well, we can discuss that later. Right now, you can't pay your rent. In a termination of tenancy case, they can't accept your rent.
But
So
they're
they can't
asking-
say
Judge,
we
we're
don't
not gonna-
accept rent, then give you a late fee. So you can discuss that with Ms. Bauer.
Yeah.
But certainly keep stockpiling the money if there's an issue regarding rent.
Judge, we're not going to raise a Park Forest waiver argument at this point, but we'd much prefer to have the rent paid.
All right, then you guys can discuss that. Defendant will allow rent to be paid. It's interesting. It makes sense. What happens is people don't pay the rent and they don't set the money aside. They spend it on car insurance or groceries or lottery tickets or whatever. And then when it comes time to pay the rent, the money's gone. So there is certainly logic in continuing to pay the rent. We don't have an escrow order. And that way the rent will not be an issue. So I guess I can accept that. All right, this matter's continued all the way till Friday, February 27th, which is about a month from now, at 11 o'clock. If the matter is resolved, that's fine. If it isn't resolved, we'll set a jury trial date at that time. All right, we will have a finalization of any witness and exhibit list by that time. Mr. Kromendijk, any further?
Nothing.
All right, I'll see you guys in February or sooner if you do work out a resolution.
Ms. Bailey, I will
All
give
right,
you a
Ms.
call.
Bailey. My advice
Your
is you
Honor.
stay in contact with your lawyer.
Yes, thank you, Your Honor. Thank you, Meg, and thank you,
All right.
Mr. Kromendijk.
All right, Mr. Millerant, you as well. Thank you both.
Yep.
Thank you,
Thank
Judge,
you.
for the time. Steve?
All right, well, we inched a little closer to the finish line. I'm hopeful they can come up with a solution. We'll stop our live feed. We'll be back at 10 for a sentence.
Yes, Your Honor, I can call Miss Christina Verzola. She's on Zoom as Tina Verzola. She's 9 and 10 on the 9:30 calendar. I do believe there is a party to the case.
Thanks. Okay. All right, so as far as the confirmation, Eric. What case is that? Completely related to court later. Yeah. I don't have your stuff. Why am I not seeing it? Okay.
It's a doozy of a day.
It's the day.
9 and 10 on the 9:30.
What's the case number?
25 DV 0918.
I'll give you a message later then.
Okay.
Okay. Okay, sorry about the interruption there, but I wanted to know if we were confirming for trial or not.
Your Honor, we are not confirming for trial today. She was originally Mr. Pazderka's client, but since Mr. Pazderka has been transferred to felonies, she's not yet been reassigned, but she will be reassigned in the coming days. We're asking for a good cause continuance for her to be reassigned to the new attorney and to have pre-trial and trial confirmation dates set.
All right, that sounds like a good reason. Does the city have any objection? All right. We'll reset the hearings then. Definitely good cause there. All right. Let's set trial to April 6th and trial confirmation to March 25th. And I know this is calendared for a no contact order motion, but I have to tell you, I don't see that. I don't see it docketed, and I don't see a motion to address the no contact order in the file either. So I don't know exactly how that came about.
I'm not sure if you can hear me or not.
Yeah, Ms. Brazola, I can hear you.
Okay, yeah, I do have noticed that the protection order for the person, Mr. Amata, of the no contact order, he is in court today to have the no contact order lifted, hopefully. I'm not sure of the status of any of that. I have not had any contact with him, but I did get notice that he was supposed to be in court today in a different courtroom to have that hopefully lifted.
Okay. That's
I'm so sorry.
entirely-
I'm leaning so close. It's hard to hear.
The state has not received anything. Is there?
How did this get calendared?
I did it with the clerk.
I mean, normally the calendar clerk would.
They were somehow both calendared on the same day at the same time, but in different courtrooms, and so I'm not sure.
Your Honor, Mr. Amato has said that he did it at the clerk's window over here.
That would be how it would normally go.
Oh, I'm sorry. I didn't see that he was in the courtroom.
This is blank though.
I know, but I filled it out.
Oh.
I just printed it out and brought it here.
Did you have it there?
They have it.
You said that was in November sometime?
Around November, I believe.
Yeah, I'm looking at November's entries in this case. I don't see anything here either. Normally, the court clerk makes a docket entry to know that it's been done, and then the actual motion that you file is put into the court file, and I don't see that either. So it makes me think that it may have been put accidentally in the wrong file. I'm gonna see if there is another case involving Ms. Verzola that it might be in. Doesn't appear that there is, not in this court anyway. Let's see. There's a Lacey case. Let's see if that has it. No? Yeah, Ms. Verzola, I see you've got a Lacey case as well, but I don't see any notations or any documents in that case about this order. So, all right, let me just ask you real quick, sir. What is it you want the court to do with regard to the order?
I'd prefer to like get it taken care of and not have it anymore.
Okay. Okay. And this order, let me see, it was put into effect. In this case, first came to court, and that was in September 15th. I see at the time that when the order was put into effect, there were no exceptions or anything in it. Get somewhere with this case now. December, look at the docket entry for December 11th. Yeah, could it be on December 11th you came in and did that?
I really don't know the exact date.
Yeah, something got missed. I don't doubt that you did it. You know, mistakes like this can happen. And all right, so you want the order to be removed entirely. And can you tell me sort of in your own words why it is that we should change that?
I was never afraid of her. She's never made me feel any certain way about fear or anything of hers. So it never really was a safety concern. But we're both homeless right now, so I don't know. Jumping house to house right now for me is kind of hard, and I don't know how she's doing right now because we haven't talked to each other in a while. But I don't have any safety concerns with it or being around her, and I kind of just want to be able to talk to my girlfriend again.
Okay, now I have some concerns about that. And these are my concerns. There's been a charge filed by the city of Lacey against Ms. Verzola for violating this very same no contact order. That was in December. She came to court on that. Ms. Verzola, you came to court on that, you got arraigned, And then on
Yes.
January 12th, you missed your pretrial hearing and the court issued a warrant for your arrest at that time. So my concern is that
Oh, can
there's at least substantial reason to believe that there hasn't been full compliance with the order.
Oh, I'm so sorry. Can I explain that? I'm so sorry. It's hard for me to hear on my phone. I was actually in custody in Grays Harbor, and they were supposed to contact my attorney.
So, Ms. Brazzola, your microphone's been muted. I'm going to ask you to don't interrupt the court when I'm addressing other people. That really doesn't work, not in court or really anywhere. And then if your technology or your equipment is not good enough for you to be able to participate in court hearings, you're going to need to be here. So, Ms. Brazzola, you can go ahead and unmute yourself and answer my question. Where are you right now?
Sorry, I'm currently in my car right now.
Where are you?
I'm in a parking lot in Lacey somewhere, like a gas station.
I'm in session here until 12 noon, and I want you to be here. So come down here to the courthouse and make contact with your attorney, and we'll resume this case.
Okay. Can you just tell me which courtroom I should be at?
Courtroom 2 at the courthouse.
Okay, perfect. I will be there in just a few minutes.
All right. So sorry about that, but we're going to have her here and we'll be able to do this. Okay. Okay. I see Ms. Brazzola has appeared. Let's take that back up. Ms. Brazzola, would you join Ms. Clark here at the table? So I've got a number of concerns about the request to remove the no contact order, as I was starting to explain before you had your technical issues.
Okay, sorry. Sorry about that.
And I know that that request has been made, and we did manage to track down the request so that we can actually see it, in front of us and address it. So the concerns that I have regarding that request are that, one, there is a pending warrant in your Lacey case, which is a failure to appear for a hearing based on a charge of violating this same protection order.
Yeah,
Two,
I just found that out. I'm so sorry.
in Grays Harbor County District Court on January 11th, you were charged with driving under the influence and violating the same protection order. And when I evaluate a request to remove an order, one of the things that I'm looking at is if there's been compliance with it. And if there hasn't been, I'm not convinced that there will be future compliance with it. And that means I'm far less likely to want to remove it. Now, the other part of this equation is that when I see that there's a failure to appear in court on further charges, I'm further concerned that there's a willingness to comply with the orders of the court. So what I'm considering doing is A, not changing the order because I'm not confident that it's been complied with or will be in the future. And two, taking you into custody on that warrant for that other charge that is pending in Lacey that you missed your hearing for. And considering further violations of your pretrial release conditions, in this case, based on those charges in Grays Harbor County from January 11th. So, Ms. Brazzola, I've had a lot of concerns about your situation. Ms. Clark?
Yes, Your Honor. She was not aware of the Lacey warrant. I did direct her to the clerk's office. She does have documentation for a bench warrant quash hearing. So as soon as she was aware of that, she did take care of it. As far as the NCO motion, I believe a lot of what the further violations are about has been just the stress of not being around this person who she cares about while also navigating being houseless. And so I am aware of the court's concerns about whether or not she follows the order. I would defer to the court on whether or not the order continues. My main concern is not taking Ms. Verzola in today in custody on the Lacey warrant.
All right, well, thank you for stopping at the counter and scheduling that hearing to address your Lacey warrant. You definitely want to you don't want to forget about your court dates. You definitely don't want to ignore them.
No, and can I just say, I had no idea until today that my current state attorney was moved to a different district. And so I have had no contact. I've sent numerous emails, phone calls. I've tried to get a hold of him so many times. I had no idea until today that he was not even working in this county. So when I had missed my court date and I was in custody in, I think, Grace Harbor, I had tried to contact him. I had had my mom contact him, left voicemails. Now his voicemail is full. Apparently he doesn't even work in the district. And so that's why that's why I had missed the original court date, is because I had no idea that he was not even working for this county anymore. Or for this district, and I just had no idea how to get a hold of anyone.
Yeah, I have another question for you.
Yeah, of course.
As I'm considering these things. Do you know when your next court date is in Grace Harbor County District Court?
I have it all in an envelope in my car.
And there's a reason I'm asking.
Yeah.
Okay, the notes in the court file from the Grace Harbor County
I have one
District
tomorrow.
Court, those notes say that you missed your court hearing on January 15th. They didn't issue a warrant for you at that time, and they did reset your court date to January 29th, which is tomorrow.
Oh, yes, I do have tomorrow in my.
Okay. All right.
Sorry, I have all my ones for this week scheduled.
Okay, I'm not going to rescind the no contact order for the reasons that I stated. And in addition to that, I understand that you and sir, you as well are navigating homelessness. I know that's not easy. And it makes it harder to do just about anything. But I also know that people who are homeless are also particularly vulnerable to pressures and violations that take place out of the public eye. They're particularly vulnerable. That applies to both of you, but what I'm concerned about here, sir, is you. So under these circumstances, I'm not going to remove that order or change it further. That could change, though, if there's demonstrated consistent compliance with the order and appearance at your court hearings. Now, I've reset dates. Let's print a court date for her for March 25th. So you can take it with you. I won't take into custody on that warrant. Now that I know you're going to be in court for Grace Harbor County tomorrow, right? And yes, I know that you're going to be here for your warrant quash hearing in Lacey as well.
Yes, I will be in attendance for everything. Sorry.
Yeah, that date. Okay, you've got a lot on your plate, Ms. Verzola, but I think you've got it all organized now and you'll be okay.
Thank you so much.
State of Kansas versus Timothy Lee McKendrick II. Case numbers 25 CR 476, 25 CR 472, 25 CR 475. Brett Sweeney appears for the state. Joseph Favre's defense counsel. Defendant McKendrick appears from the detention facility Zoom location. What are the status of these three cases that you would announce at this time, Mr. Favre?
Judge, so as we announced on Monday at Mr. McKendrick's other case, we were looking for a global plea. We have reached a global plea agreement in this case, so Mr. McKendrick will be waiving his right to a prelim in all three matters, and then we are ready to announce the plea on the record.
Well, what is the plea agreement that's been allegedly reached here?
So, Judge, in case 25 CR 475, Mr. McKendrick will be pleading no contest to all counts as currently charged. So that is counts 1, 2, and 3. In both 25 CR 472 and 25 CR 476, state has agreed to amend both of those felonies to harassment by telecommunication device, a Class A non-person misdemeanor. In each case, Mr. McKendrick will be pleading no contest to both of those counts of harassment by telecommunication device. At sentencing, the recommendation will be mid-box, follow presumption, and Ms. Norris will like them to run consecutive to one another. So that's what we have agreed to.
All right, Mr. Sweeney, you're in agreement with this announcement?
Your Honor, that does seem to be consistent with the emails that have been shared and communicated to Mr. Favre by Ms. Norris regarding the state's offer.
Okay, so he'll be pleading to all 4 counts in the 475 case, Mr. Favre?
Judge, I believe it's only 3, and he'll be pleading to all 3.
The amended information that I have before me has 4 counts.
She sent me, hold on a second. Let me double check my email here. I apologize. It is all 4 counts, Judge. Let's see.
All right. All right, Mr. McKendrick, you've already waived your preliminary hearing rights in the 472 case. It's the court's understanding that in the other 2 cases, 475 and 476, you'd be waiving your right to a preliminary hearing and instead entering pleas to resolve those cases in accord with what your attorney has announced. Is that indeed your intention here today?
Correct.
All right. I've got a number of questions I need to ask you regarding the taking of a felony plea, specifically in the 475 case. If there's any question asked of you that you do not fully understand, I will give you the opportunity to confer privately with your lawyer, Mr. Favre, at any point. Just let the court know if you need that time to get further advice, okay?
Yes, sir.
State your full legal name for the record.
Timothy Lee McKendrick II,
How old are you right now?
27,
What's the highest level of formal education that you've attained?
a diploma, graduated high school.
Do you believe you're going to have difficulty understanding any of the legal concepts we're going to be discussing in court here this afternoon?
I think I should be okay.
Have you ever been adjudged to be mentally ill?
No,
Are you currently under the influence of alcohol or any drug?
no, sir.
Are you currently taking any type of prescription medication?
No, sir.
Are you supposed to be taking any mental health meds that you are not currently taking?
No, sir.
So do you believe now your mind is clear and that you have a full understanding of what's going on here in court?
Correct.
Did you receive a copy of these various charging documents that are involved in these cases?
I believe so, yes.
All right. Do you understand the nature of the charges in the 475 case? And let's go through those. You understand the nature of the crime of criminal threat?
Yes.
Harassment by telecommunications device?
Yes.
You understand the charge of stalking?
Yes.
You understand that when you enter pleas of no contest, you are not necessarily admitting these various acts that have been charged in these various cases, but you're also not contesting that you be convicted just the same. You understand that?
Yes, sir.
So understand that by entering pleas of no contest, you give up any legal defenses that you might have had to these charges.
Correct.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses at your trial with the assistance of your lawyer, and that at such a trial you could present evidence on your own behalf and subpoena your own witnesses to court?
Yes, sir.
You also understand that at such a trial you personally would have a privilege against self-incrimination, which means that if you wanted to get up on the witness stand and testify in your cases, you could at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. You understand that?
I do.
You understand that when you enter pleas of no contest, you give up these valuable trial rights that the court has described.
Yes.
Kendrick, do you also understand that you have a right to a trial by jury, and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yes, sir.
You understand that when you enter pleas of no contest, you give up your rights to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt?
Yes, sir.
You understand that you have a right to appeal a guilty verdict if you have a trial?
Yes, sir.
You further understand that you may appeal your sentences after entering pleas of no contest, but generally you may not appeal your judgments of conviction after you enter such pleas?
Yes.
Are you aware of the various sentences that could be imposed as a result of these no contest pleas that you are attempting to make?
I believe I do.
Okay, well, let's go over those.
Okay.
Most importantly, the felony charge, which is involved in the 475 case, criminal threat, a level 9 felony, on the non-drug offense grid under the Kansas Sentencing Guidelines Act in the most favorable criminal history category of I, you could receive as little as a 5-month prison sentence. In the worst criminal history category of A, you could receive up to a 17-month prison sentence. So the sentencing range is 5 to 17 months in prison, depending on your criminal history. As you sit today, Mr. McKendrick, we do not know with certainty what your criminal history is. You, better than anyone else here, should really know what your own criminal record looks like. But that would be researched by the Court Services Department, and based on the outcome of their research as of the date of your sentencing, that determines where you fall along the level 9 line, and then you'll be sentenced accordingly. Do you understand that?
Yes, sir.
Okay. You also understand that you could receive up to a $100,000 fine for that offense.
Correct.
Okay. Harassment by telecommunications device, stalking. Those offenses are Class A misdemeanors punishable by up to 1 year in the county jail and up to a $2,500 fine for each offense. Do you understand that?
Yes, sir.
Okay. In addition to any fines that can be imposed, are you aware that you could be assessed and be required to pay court costs, certain fees, and restitution that are owed to victims as part of your sentencing orders?
I didn't, but I do now.
Okay. Also, I want to point out to you, Mr. McKendrick, that if you have 2 or more person felonies on your record at time of sentencing, you would be presumptive prison here.
Okay.
Does that want to change your attitude toward these pleas?
Your Honor, I've never been in trouble besides a traffic ticket, so I don't think that's any of my concern.
You understand that the Kansas Sentencing Guidelines Act contains special rules. You understand that if any special rules apply to you in your situation, it could affect your eligibility for probation or otherwise affect your sentence?
Yes, sir.
You understand the difference between consecutive and concurrent sentencing?
Yes, sir.
Concurrent sentencings run all at the same time. Charges or cases run the same time obviously results in a lesser overall incarceration sentence. However, consecutive sentences are boxcarred back to back. You serve all of one before you even start the other, which would obviously result in a longer potential period of incarceration. Do you understand that?
Yes, sir.
You also understand that generally it's up to the court to determine whether your cases or your charges run consecutively or concurrently.
Yes, sir.
All right. You understand that as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which would be your state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing.
Okay. Yes, sir.
You understand that both probationary and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances.
Yes, sir.
You had an ample opportunity to discuss legal matters like this with your attorney, Mr. Favre, before proceeding here today.
Yes.
You want any more time with him privately before we go further?
I think we're good.
Are you satisfied with the services and advice given to you by your lawyer?
Yes.
Now, these no contest pleas that you're attempting to make here, have they been based upon any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
No, sir.
You understand that if there are any plea deals between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes.
So how do you plead in the 475 case to count 1 criminal threat, a level 9 person felony?
Is this the one, I want to say no contest?
That's right, no contest.
And to count 2 harassment by telecommunications device, a class A misdemeanor?
Same.
And to stalking in count 3, a class A person misdemeanor?
No contest.
And to count 4, harassment by telecommunications device, a class A misdemeanor?
No contest.
All right. In your other 2 cases, of course, understanding that you're entering pleas to an amended count of harassment by telephone, class A misdemeanors in 2 different cases. What are your pleas in those cases?
Honestly, I would assume. What are the choice? What is it all? So I can do no contest, not guilty. I want to say not guilty.
Not guilty, no contest, or guilty, but we're going to do no contest for these.
Oh, no contest. Yeah, no, my bad. No contest.
Okay, you sure you want to enter no contest pleas to those other 2 misdemeanors?
Correct. Yes, sir.
All right. I'll need a factual basis for each of these offenses, Mr. Sweeney.
Yes, Your Honor. So I guess first, obviously, starting out with the felony case 25 CR 475. On the listed date for the criminal threat, October 9th, 2025, Mr. McKendrick showed up at a business location in Andover, 3122 East US Highway 54. That's in Butler County, in an attempt to find Miss Williams, the victim. And while there, he also encountered another employee at the business, Christy Bigley. Mr. McKendrick was pretty animated and it seemed like agitated. He was making verbal threats toward Miss Williams and her children. Miss Bigley was a witness to that. Miss Williams at one point made a statement or through Miss Bigley that it seemed like the threats towards Miss Williams's life. Williams stated that this made her in fear for herself. Officers, in speaking with Miss Williams, were made aware that this had kind of been an ongoing issue, it sounds like. And it also, on that date, October 9th, there had been her phone was checked and it looked like there had been 30 missed calls, 73 text messages by Mr. McKendrick toward Miss Williams in what looks like it had been a prior relationship and these kind of threatening, agitated messages towards Miss Williams. And I would note that they similarly would have been sent to with the intent to abuse, threaten, or harass. Also, the phone calls through the telephone harassment would have gone through the dates of the 14th of August, 2025 through the 9th day of October, 2025 in a similar fashion where Mr. McKendrick engaged in a course of conduct to essentially target Miss Williams with these messages in a way that would constitute stalking. And then finally, Your Honor, similar to the other counts, on the 17th of October, 2025 and the 18th, in between that date and the 18th day of October, 2025, there were similar messages, calls, and harassment by phone from Mr. McKendrick towards Miss Williams that would constitute another violation of telephone harassment. I don't know if that, I would think that that would suffice as a factual basis.
Okay, just a moment, Mr. Sweeney. Let me stay on this case for a moment. Count one. What did he specifically say that would be construed as a criminal threat?
As far as specific statements, I don't see anything specifically in the affidavit as far as verbatim, although it's stated that there were specific threats towards Miss Williams and her children that were communicated while he was at the Early Bird Child Care Center, which is where Miss Williams worked at the time, and then Miss Bigley would have been a witness to him making those statements and verbal threats.
Judge, in 25 CR 475, we would stipulate that the statements made in that case, let's see, were, I apologize.
And no, go ahead, Jeff.
I was going to say that the statements, there were statements made by Mr. Williams. Making sure I'm looking at the right affidavit here, because I think I may be looking at the wrong affidavit, actually. Let me see.
And I think I can answer that. I've got the specific statements that he made
Right.
Bigley.
Right.
I thought, Mr. Sweeney.
Yeah, so he said, and I guess this is a paraphrase, but McKendrick also made what seemed to be suicidal comments towards Bigley. He made statements that he wasn't going to show up to court because he had a traffic warrant through the city of Wichita. He said, "Don't be surprised if she," meaning Williams, "doesn't show up to work for the next few days. I've been warning people and can't guarantee I won't do anything today." She stated McKendrick about how this kind of behavior wasn't worth it. That was what Miss Bigley was telling him and gave him advice on what to do with these kind of things. Bigley stated McKendrick was persistent in his threats and that he was going to harm or kill Williams and her children.
All right. Court satisfied in regards to the 475 case. What is the harassment by telephone contemplated by the 472 and 476 cases?
Yes, Your Honor. Let me grab the 472 case first. Your Honor, the state believes the evidence in this case would be that on the 14th day of August 2025, there were text messages from Mr. McKendrick's to Miss Williams. Again, some of those messages contained a statement, quote, "Now you really finna be dead. That's crazy. Killing your bitch ass the day I find out. I will off your fucking head because you can't control me." There's several more messages, but I certainly think that those messages communicated over a telecommunication device on that date would constitute harassment by telephone.
Court agrees. And the other case?
And 25 CR 476 on the 21st day of September 2025. Mr. McKendrick was again in contact with Miss Williams, in which he stated, "I already have a warrant. I don't want," and this was over a telephone. that Mr. McKendrick stated, I don't want to do the court system. I will die. I will kill about my respects. He repeated that again. So if I got to hurt her, meaning Miss Williams or her boyfriend or whatever the fuck I have to do, I will do that to be in my child's life or not in my child's life. It just kind of goes on and on. But that was actually verbally stated to Miss Williams on the phone on that date. And that resulted in obviously another charge against Mr. McKendrick, and that was also investigated by the Butler County Sheriff's Office. Well, let's make sure. Actually, the Augusta Department of Public Safety was the investigator on that case. And again, on all these cases, Your Honor, I believe Miss Williams was a Butler County resident and would have been in the Butler County area at the time of these offenses. And in that case, was at her residence or at a location at 211 East Summit in Augusta.
Very well, Mr. Sweeney. All right, Mr. McKendrick, do you now enter pleas of no contest and accept conviction in the 475 case for criminal threat, harassment by telecommunications device, stalking, and a second count of harassment by a telecommunications device?
Yes, Your Honor.
You also enter pleas of no contest freely, knowingly, and voluntarily to accept conviction in the 472 case for Class A misdemeanor, harassment by a telephone, and in 476 case, harassment by telephone, Class A misdemeanor.
Yes, sir.
Right. Mr. Favre, do you know of any legal reason why the court shouldn't accept your client's pleas?
I do not, Your Honor.
Mr. Sweeney, are you aware of any such legal reason?
No, Your Honor.
Mr. Kendrick, are you aware of a legal reason or any other good reason why the court shouldn't accept your slew of no contest pleas made here today?
No.
Court will accept the no contest pleas made by the defendant and finds that those pleas are made voluntarily. He has an understanding of the nature of the charges against him and the consequences of the pleas, and a factual basis for each charge does exist. The court finds the defendant guilty and adjudges him therefore convicted in the 475 case of criminal threat, count 1, level 9 person felony, count 2, harassment by telecommunications device, a Class A non-person misdemeanor, in that count 2, and then in count 3, stalking, a Class A person misdemeanor, and in count 4, harassment by telecommunications device, a Class A non-person misdemeanor. Further, the court finds the defendant now convicted in the 472 case of harassment by telephone, a Class A misdemeanor, and similarly in 476, harassment by telephone, another Class A misdemeanor. Any other charge not contemplated by this plea would be dismissed pursuant to plea agreement. Court will order a pre-sentence report be completed to accurately determine Mr. McKendrick's criminal history, and the court will set an appropriate date for sentencing. McKendrick, I'm going to order you to comply with any pre-sentence assessments that may be required of you.
As always,
Needs
sir.
assessment or substance abuse assessment, so that we don't have any delays in your sentencing proceedings.
All right.
You check your calendar, Mr. Favre, for Monday, March 30. I'll be looking at 1:15 p.m.
That's perfect, Judge.
Right, the court will set McKendrick's sentencings for 1:15 p.m. Monday, March 30. Court contemplates that this will be a Zoom sentencing proceeding at that time. 1:15 Monday, March 30. Mr. Sweeney, anything else the court needs to address at this time?
Not that I'm aware of, Your Honor. Thank
I
you.
think your office may have the responsibility to be drafting some amended informations.
I think that's accurate, Your Honor, and we will.
All right. Appreciate it. Mr. Favre, anything further at this time?
Judge, if we could address the issue of Mr. McKendrick's bond. I'm not sure what his total bond is. We're asking the court at this time to set a new bond for him in the amount of $5,000 cash or surety. He is, as he noted, very minimal criminal history. He's presumptive probation on this. He has been in custody for an extensive amount of time. I think he's been in for 60 plus days now. Is that right, Mr. McKendrick?
Yeah, something like that.
It's been a fairly long time, and he is hoping to get out and to save his work, which he lost when he got put in custody. So try to get his work back. So we asked the court to consider allowing him to have a modified bond at this time.
Also, I want to get myself into anger management if that helps at all, you know.
Mr. Sweeney, what's the state's position here?
Your Honor, I was trying to do the aggregate amount on the bonds. If I'm correct, it looks like 25,000 on the three, if you add them all up, with two 10,000s and a 5,000. I don't know that the state would necessarily maybe object to some modification of the number, although I still think that there ought to be a significant cash or surety amount. And then I still think the GPS, which looks like it was a condition of the original, at least on one of the cases, a bond requirement, is still appropriate, considering the nature of the facts in all three of these cases. So I'll leave it to the discretion of the court beyond that, but I certainly think GPS and some sort of significant cash amount as far as bond.
And Judge, I'll tell you, we do not object to GPS. Mr. McKendrick missed a hearing, and that's why he was put in. But it wasn't something where he was running. He missed the hearing, and he ended up making a mistake. He got in touch with me later, but it was too late. He had to go into custody. So he doesn't have a big history of running from this court. So we'd ask for the modification, and with GPS is fine.
Right. I understand the proposal that's been made, but the court will reject it for several reasons. Mr. McKendrick, there's always a problem, which is evident when someone has three pending cases in the very same county district court all at the same time. Second of all, part of the comments that you've made and documented by your communications is that you won't show up in court.
But Your Honor,
well, you can try to explain that away.
I'm not trying to explain.
Once that's part of the record in the case, the court takes that into account, that you probably meant what you said when you said it, and that you very well may mean that now. And I'm not going to give you a chance
to
prove me wrong.
I didn't know I missed any court dates. Honestly, I thought I've made it to every single one while I was out on bond.
Furthermore, you've apparently, according to what's just been announced, you missed a previous court date on one or more of these cases that are currently before the court.
Can I know what date that was? Because I've talked to my bondsman and he gave me every single court date and I've made it to every single one.
Okay, I'm going to ask for clarification on that.
And the ones in El Dorado and the ones in Augusta.
Let me take a look, Judge. I hope I'm not misremembering here. I thought we had, but maybe it was just he was arrested on the third case while the other two were pending. Because I got the first two. And then the third one happened afterwards and he was out. So maybe I may be misremembering here. I'm looking through my notes.
From my understanding, I'm back in custody because I was walked. There was a case, which was this last criminal threat, which I had on the January 26th, that it was the female judge did not pursue until I was out on bond for maybe a couple weeks. And then when she told me she was going to summon me, I came to court. Joe was there. There was a couple police officers in the room with me. She told me she was going to summon me. I go home for maybe 4 or 5 days, and I had 6 police officers outside of my door telling me that I had a warrant for my arrest. From my understanding,
Judge, I think that's accurate, and I apologize for my misstatement. I think he did not fail to appear. I think he was out on the first two, and then they issued a warrant for the third one. I think that's what occurred.
Yeah, I've missed.
I see on 2 of these 3 docket sheets that he failed to appear on December 29, 2025. Apparently in Judge Hart's court, his docket notes indicate defendant failed to appear.
That's not
With an
true.
arrest warrant that issued from there. But that's not determinative in the court. The court's not inclined to change any of the existing bonds in any of the three cases. Mr. McKendrick, at least this way, I know you'll be available to court services if they need anything from you. And you'll be available to this court for sentencing on all three of these matters when we go to court in late March.
And so
I'll leave the bonds. There are bonds set apparently in each of the three cases. I'll leave those were previously set.
I've not missed any courts. That's false. That's false.
It was the first appearance. That's what I was thinking, Mr. McKendrick. That's what the Judge Hart one was.
What first? No, I came to court on the 29th of December.
I'm going to change the court's orders.
Thank you, Judge.
So the request is denied. Bonds remain as previously set, with any previous condition intact.
This is crazy. All because I'm trying to be a father.
If there's nothing further at this time, the McKendrick matters will currently be in recess, and this meeting may be ended for all at this time.
Oh, God. All just for trying to be a father. I mean, let's be honest. Is he talking about being a priest? I should probably lean this way. This is where the microphone is. Is he talking about being a priest with the Catholic Church? Because he's not talking about being a good dad. Not sending text like that. My God. Holy moly. Well, ladies and gentlemen, now you know the rest of the story. And I'm your lone wolf Usul. I've been working all day getting this stuff put together for you. The Milleran saga was the coup de grace of the whole presentation. And if you missed that, use the time cards down in the description. Check it out. There'll be a little bit more to that, I think. If they know what's good for them, it won't be in front of us. But, you know, it's like we always say, don't end up in court. And if you do end up in court, don't act stupid in court. Because if you do, we'll be watching. Ladies and gentlemen, thank you for watching tonight. I do want to say a very special thank you to a very special set of people. Donald, Kiriana, Original Danielle Nina, Rhonda, Tara, all of you who donated tonight to the cause. The contributions are greatly appreciated. Without your contributions, this humble show could not even exist. We'll be back tomorrow, 8 p.m. Central, 9 p.m. Eastern, every single night. Same wolf time, same wolf channel. Stay smooth, keep it sleazy, and party on, dude. I'm out. Later. Well, you know it's coming, right? Thank you, Marty. The double done last night, I think that was pretty fun too. I'm thinking about what to do tonight because this is our obligatory reference to Ferris Bueller's Day Off, where he comes out of the shower, I believe is what it was. It's been so long now, I don't even really remember. I haven't watched it recently. There's no more. Why are you still here? Go. But tonight, I'm thinking about Bill and Ted. And one little snippet I love from Bill and Ted's not Excellent Adventure, but the other one. I don't remember which one it is. You can tell me in the comments. Identify this movie reference. Station. That's it. Bye.